And I also, at this point, am going to admonish and rebuke you, Miss Love.
Getting rebuked in open court is the wildest thing I've ever seen. I'm not a lawyer, but there was so much that happened on day 122 of the YSL RICO trial. But I'm going to skip to the biggest thing that happened because it was wild. Buckle up, because you're gonna have to really pay attention to follow this one. So as expected, Antonio Sledge, aka Moontunk, was called to the stand, and one of the factual acknowledgments in his plea deal for this case has to do with a 2015 drive-by shooting that he, Demikion Garlington, and Quindarius Zachary were involved in. In 2017, Antonio Sledge accepted a plea deal in that case, but Attorney Love still has him lay out what exactly happened the night of the incident.
Tell us what happened in the drive-by shooting.
At the club, Garlington got jumped off, which didn't have anything to do with anyone else besides me and Garlington. It was a group of guys. I didn't see no faces, none of that. I assisted Garlington, and then it went farther with us fighting. Then me, Garlington, and Zachary, we went and we did what we did.
Are you aware of whether these people that you pulled off of Garlington claimed to be a member of any particular gang?
I can't really say what gang they claim.
Are you familiar with a person by the name of Kelvin Watts, who answers to the names Kel and Shell Kel?
Know of him, but I don't know him.
When did you learn he was Gift Gang?
I know it was after that video.
What video are you referring to?
The video of me and Quindarius.
Did you do in the video?
I told him if he was looking for me, I had something for someone who was looking for me, who was not my friend. He had no reason looking for me if he's not my friend.
And what did you have for him?
Whatever to do to protect myself.
You little filthy ass nigga. We ain't really going back to no nigga. You little bitch ass nigga. I know we hate. I'm everywhere. Yeah, fuck you, nigga, Chair. Whoever else, nigga. Well, nigga. Whoa. They said I ain't really going back.
Yes, continue telling us what happened.
I left the club, and then Garlington called me to come back to get him because I left him at the club. I guess Garlington didn't want to let it go, and I was riding with Garlington, which I probably wouldn't let it go neither because another grown man ain't got no business putting his hand on no grown man. I can't remember all the details that happened that night, but I just know it was a drive-by shooting. Well, it wasn't a drive-by shooting. It was a shooting. I didn't see nobody shoot. I dropped them off and I kept going. I don't remember, but I know I pleaded guilty to it. I don't remember all the details, but I pleaded guilty to it.
You were talking about having pled guilty to charges related to the drive-by shooting or to the shooting.
I pleaded guilty.
Excuse me, Judge. At this time, can we get the instruction, please?
Okay, so at this point, since Attorney Love is about to start reading acknowledgments or like statements from the plea deal, Bruce Harvey, the ponytail lawyer, asked that the judge read a limiting instruction to the jurors. Limiting instruction is basically the judge telling the jurors, hey, just because Antonio Sledge pled guilty to the things he was charged with in this indictment does not mean any of the other defendants in this trial are also guilty of the things they've been charged with. And also, if today Antonio Sledge decides to deny everything he said in that plea deal, you as the jury can use what he agreed to in the plea deal as like meaningful evidence against all the defendants in this case. So that's what Judge Whitaker reads to the jury.
Ladies and gentlemen, you are about to hear evidence that a co-defendant in this case has pled guilty to some of the charges in this indictment. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider the co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, you may consider the witness's prior inconsistent statement, that is, his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have on the issues on trial.
Thank you, Your Honor. So, Mr. Sledge, you mentioned pleading guilty to charges related to the April the 28th, 2015 shootings that you were just talking to the jury about. And at the time you pled guilty, did the prosecutor tell the court that the evidence would show that on April 28, 2015, Mr. Garlington and Mr. Sledge were at a club called Club Crucial on Donnelly Hollowell Parkway earlier in the evening, and preface this by saying Mr. Garlington, Mr. Sledge, and Mr. Zachary at this time were members of a gang called YSL or Young Slime Life. There had been a falling out carrying from the fall of 2014 into 2015. This, for lack of a better term, gang war was going on at this time. Mr. Garlington was jumped at the club by members of a rival gang. Aaron Mills, Dominic Carter, and others that are members of a gang which is a subset of If Gang, which is a gang that the dispute was going on with at that time. A decision was made by Mr. Sledge. They called Mr. Zachary, the co-defendant, to retaliate in some way. The evidence will show that Mr. Sledge drove the vehicle. Mr. Garlington and Mr. Zachary were inside with weapons, and they first drove by Adele Avenue, address that Darren Mills actually used and stayed at. He was one of the individuals that had assaulted Mr. Garlington earlier at the club. Mr. Sledge drove by and they shot at the house. Aunt of Darren Mills sustained, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. After that, Mr. Sledge drove over to 1903 Drew Drive. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Detectives got a lead that Mr. Garlington and Mr. Zachary were involved, and they conducted interviews.
Yes, sir.
I can pause there. Do you recall hearing those words read by somebody as the reason or the factual basis for the charges that were being brought?
If I can explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true, and some they said wasn't true. But I did plead guilty because I felt like it was in my best interest.
At any time, did you tell the judge, I'm not admitting this, I'm just doing this because it's in my best interest?
Well, I didn't tell the judge that. I told my attorney that.
Okay.
Yes, sir. All right, outside the presence of the jury? Okay. Yes? Yes. Okay.
So after Attorney Love has basically read out everything that the state alleged regarding that 2015 incident, Brian Steele moves for a mistrial.
Your Honor, I have a motion for a mistrial is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that Mr. Sledge is tendering the plea under Alford.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So
I'm back. Here's what's happening. As Attorney Love was reading out the factual basis from Antonio Sledge's plea, Brian Steele realizes that that plea was not actually a guilty plea. It was an Alford plea. And in the simplest of terms, an Alford plea is when a defendant says, I'm not admitting I did this, but y'all got a lot of evidence against me, so I don't want to take the chance and go to court. Instead, I'd rather take an Alford plea, maintain my innocence, but still serve whatever sentence y'all want to give me, which is usually a much lighter sentence than what they would get if they went to trial. Also, FYI, this is the type of plea that Gunna took. He never admitted any guilt. So that's what happened in the 2015 shooting case. Antonio Sledge never admitted he was guilty. So the fact that Attorney Love just read out basically a bunch of allegations by the state regarding that incident, as if Antonio pled guilty to that and that it was fact, is very problematic. And in addition to that, remember that jury instruction that Judge Whitaker read? Whitaker basically told the jurors, hey, everything Attorney Love is about to read to you, you can use as meaningful evidence against all the defendants. And Attorney Love mentioned that YSL is a gang and that they were in a gang war with If Gang. Ciao.
Ms. Love, do you want to be heard?
Yes, please. One, we'd ask that the court deny the motion for mistrial. Number two, we would ask in the factual acknowledgments.
Okay, no, see, that's the deal with an Alfred plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true, but
Yeah.
you're not acknowledging on your own, yes, these are true.
So if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 138994. But given the factual acknowledgments that were made as it relates to 22 SC 183572, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, Judge, here's what Alfred means. So
Understood.
no.
Can't get around how we got here. I'm trying to follow this factual basis, and I realize we're in a different case.
Yeah, we are. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
Does not apply.
Does not
to.
apply. And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to,
I would like-
and Your Honor, may I say one more thing? Given that, and Your Honor, I'm still reading under the annotations of that.
It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard, and the state should not do that again.
Your Honor, what the annotations say, not only not in the record, but that are calculated to prejudice the accused.
All right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So, I mean, I can grant a mistrial if you'd prefer.
Oh, no. I do not
Okay,
want a
then
mistrial.
maybe stop arguing at this point.
Yes, Your Honor.
Okay.
So the jury is called back in, and Judge Whitaker gives more instruction.
All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. There are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alfred plea. It's just named after a case called Alfred. They're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying, I think it's in my best interest to go ahead and resolve it that way. So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alfred plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. And I also, at this point, am going to admonish and rebuke you, Miss Love.
Getting rebuked in open court is the wildest thing I've ever seen.
To pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right.
Y'all, this trial never ceases to amaze me, and I hear there's more chaos on the way tomorrow.